Hi there. Welcome again to our YouTube upload. This time, one of the most interesting subject matter in taxation, estate taxation in the intertwined with inheritance or succession. And with your permission, I'd like to dedicate in loving memory this presentation to my mother and father, Captain Santos Vargas Bisquera, retired 1st Tabak Division, Armed Forces of the Philippines, and from Bangged, Abra. And my mother, Doctora Natividad Bernardo Balagtas, PhD, from Santa Rosa, Nueva Ecija, and also from Bulacan and Pampanga, a long-time teacher at DUE High School, Manila. Our get-together for this afternoon would be on the estate taxation as amended under the train law. I do not have to anymore repeat the kilometric way that I used to introduce myself. For those of you who are new in my slides, I come from three disciplines, from the field of academics, from the field of business management, and from the field of law. In academics, I have a Bachelor of Business Administration, major in accounting, and a certified public accountant. University of the East Manila, summa cum laude. I have my Master of Business Administration, University of the Philippines, Diliman, valedictorian, and magna cum laude. Bachelor of Laws, University of the East Manila, cum laude plus valedictorian. I have more than 40 years in the corporate management world, reaching the highest levels of a finance officer, Executive Vice President, Chief Finance Officer, and Corporate Treasurer of Fuji Xerox Philippines. I also came from the pharmaceutical industry, SmithKline and French overseas company, today GlaxoSmithKline. 17 years with the semiconductor electronics industry, Motorola, integrated transport with Delgado Brothers Incorporated, and petroleum oil company with Esso Philippines that became Petron. I have 35 years as an MBA professor in financial management at the De La Salle Graduate School of Business, and 10 years with the MBA program of the University of the Philippines in Diliman. In the field of law, I am an active practicing lawyer today, the incumbent Dean, College of Law, University of Manila, its Vice President for Legal Affairs and a member of the Board of Trustees, at one time Dean, College of Law of the University of Perpetual Health at Las Piñas and Biñan, and also Vice President for Legal Affairs. Luckily, I was nominated twice Associate Justice Supreme Court with a public interview before the Judicial and Bar Council in 2012 and 2016. To start the ball rolling on our sharing today, we have the following coverage of our sessions. First, I'd like to touch on property, the kinds of property, ownership, and absolute community versus conjugal partnership, as it becomes a strong foundation for the discussion on estate taxation. I will immediately go to the changes under Republic Act 10963 of the Train Law, covering the areas on gross estate, on gross deductions, on estate tax rates, and on administrative procedures. And finally, we go into the details of estate taxation, touching the details of a gross estate worth 20 million with estate deductions amounting to 18,500,000, with net estate taxable at 1,550,000, and an estimated tax due of 93,000. And so without much ado, let me now go into the subject matter of property. What is the concept of property? Property are all things which are or may be the object of appropriation or claim for ownership. And there are essentially two kinds of properties. The first one is incorporeal property, which are intangible property with no physical substance, which a person can have and can transfer ownership to another person. There are two categories of incorporeal property. The first one is what is called jura in re aliena, or encumbrances. The second one is jura in re propria, or intangible property ownership. The encumbrances would include leases, easements, right-of-way, mortgages, and servitudes. The intangible property ownership would include trademarks, copyrights, patents, and other types of intellectual property. The second type of property is what are called corporeal property, which represent tangible properties with physical existence, used in the business, and not normally intended for sale. And there are two types of incorporeal properties. These are the immovable properties and the movable properties. When we speak of property, we ultimately ask the issue on who is the owner of that property. And so ownership is a person's exclusive right and control over property, an object, land or real estate, or intellectual property, and the economic benefits of that property. And ownership may be acquired by contract, by gift, by intellectual labor, by accession, by finding, and by occupancy. And from the point of view of ownership, you can look at property in the context of an ancestral property. These are properties coming from your line of succession by inheritance, and your self-acquired property arising from your own labor. Your active involvement in order to save wealth and therefore build up your property ownership. Let us now revisit community property versus conjugal property, as it has a significant impact on how estate taxation operates. The Family Code provides the absolute community property regime in the relationship of husband and wife insofar as their properties are concerned. In absolute community property, all properties owned by the spouses before the marriage and those that they acquire during the marriage shall form part of the absolute community and is shared equally by the husband and the wife. And by way of looking into this property relationship, as the marriage is dissolved by death. We can now look into the husband's exclusive property, and since that will become part of the absolute community in the event one of the spouses should die, the decedent, and one should survive. The split of the husband's exclusive property is 50% to the survivor and 50% to the decedent. The same is true with the wife's parapernal property. 50% of that goes to the survivor and 50% goes to the deceased person. And the jointly acquired properties after marriage would equally be shared 50% to the survivor and 50% to the decedent. However, take note, in the area of ancestral properties, properties that are inherited coming from the parents, the grandparents, and the entire ancestral line, after the marriage, the husband retains his exclusive property on these ancestral properties inherited after the marriage. That goes into him if he were the survivor. The same is true with the wife on her parapernal properties representing ancestral properties given to her after marriage, where if she is the decedent, her estate will keep that particular portion exclusively for herself, her estate. And this is where the rule on estate taxation depends on the regime of absolute community property for marriages celebrated after 1988, the advent of the family code, or if even before 1988, the spouses have agreed in writing to be governed by the regime of absolute community of property. Moving now to the second aspect, which is the civil code provision on conjugal partnership of gains. Here, between the survivor and the decedent, the husband's exclusive property remains with him if he were the survivor, and the wife's parapernal property remains with her estate if she were the decedent. But on their jointly acquired properties after marriage, they share 50-50%. In the case of ancestral properties that they inherit from their ancestors, from their parents, the husband keeps 50% of the ancestral properties if he were the survivor, and 50% of his ancestral properties inherited would go to the estate of this decedent wife. The same with the wife's ancestral properties received after marriage. 50% will go to the survivor if that were the husband, and 50% will be part of the decedent wife's estate. And so that covers our background on properties as it affects taxation. Let us immediately now go to the Train Law, Republic Act 10963. There's a 6 missing there, and the changes that were introduced on the gross estate, on gross deductions, on estate tax rates, and on administrative procedures. The Train Law changes that affect the gross estate would be properties not in the Philippines of a non-resident alien is no longer included in the estate tax return for him to claim estate deductions. In the past, that is required under the Tax Reform Act of 1997. In the Train Law of 2018, this is no longer required. That is the only change so far as the gross estate is concerned. On gross deductions, the train law did touch on some significant changes. The first one, and very significant at that, and very encouraging for those liquidating the estate of their parents, that the family home deduction. The family home deduction has been increased from 1 million, to now a substantial 10 million. This is a very reasonable allowance because those who are in the middle and upper middle income groups who purchase their family home, and this is their major asset, will now be enjoying a shield of 10 million before the estate tax gets to be computed. It used to be only 1 million. Second effect on the family home deduction is that there used to be a requirement that the barangay captain should certify that the family home is the residence of the decedent. That is no longer required under the train law. The second major amendment is in the area of standard deduction, which used to be also 1 million, similar to the family home deduction. The standard deduction now has been increased from 1 million to 5 million. In some of the commentaries, some tax observers noted that when the government removed the expenses that included the funeral expenses, the medical expenses on the last ailment, and judicial expenses for liquidating the estate, these were all removed. They become really so complicated, even ripe for potential graft and corruption on auditing, on tax auditing. And so the government said, let us just delete all of these deductions, but let us now elevate the standard deduction from 1 million to a substantial 5 million. So these are the two major amendments or changes in the tax code coming from the train law on estate gross deductions. I already mentioned this a while ago. The funeral expenses, judicial expenses, and medical expenses were removed. So there is no more any complications between actual funeral expense not exceeding 5% of the gross estate but not exceeding 200,000. That has all been set aside, including judicial and medical expenses. For a non-resident alien deduction, the train law removed for a non-resident alien the deductions for expenses, losses, indebtedness, and taxes, but in the same line, increased the standard deduction to 500,000. The next change came in the estate tax rates. Before, estate taxation is a very complicated process even for CPAs and lawyers because it uses a table, a graduated table, ranging from exempt, the first 200,000 net estate being tax exempt, and moving from 200,000 to 500, 2 million, 5 million, 10 million. And when you exceed 10 million, then you get hit by 20%. The train law simplified this system and abandoned this tabular approach by simply granting a 6% flat value on value of the net taxable estate as the estate tax rate, 6%, which essentially approximates now the capital gains tax of 6%, which encouraged in the past the cheating, literally, of transactions where there is a pseudo sale to the children so that the rate of 20% in the event of the donation mortis causa or donation by death is subjected to 20 million, 20% rather, 20 million, 20%. And therefore, the so-called tax avoidance scheme is to conduct a pseudo sale, making it appear that the children purchase the estate of the properties of their parents on a deed of sale approach, and therefore just pay 6%. That particular estate planning scheme is no longer in place because now it is the same 6% whether you use the capital gains tax on a pseudo sale or you simply await the death of the owner of the property. In donation mortis causa, you also pay a 6% value estate tax rates. Moving now to the administrative procedures that were adopted under the train law. First, the notice of death. There is no more need for notice of decedent's death, previously required to be made within 2 months after said death. This particular thing is almost always not followed because 2 months would still be the period of mourning and sadness, would probably not give priority to taking care of filing notices and going into the details of the financial assets of the deceased person. The second one, which is very significant, is the withdrawal limit of cash in banks. The train law now allows the withdrawal of any amount from the bank subject to the 6% final withholding tax with no more BIR certification and the 20,000 limit. I have personal difficulty meeting this when my mother passed away, and when we took an inventory of her bank accounts, there were a number of significant deposits all over the branches of the bank in Metro Manila, especially in Las Piñas. And we were limited to 20,000. But the more difficult one is to get a BIR certification authorizing you to withdraw that particular limited 20,000. Today, you can go to the bank and simply manifest that you are the executor administrator and you would like to withdraw the balance of the account provided there is a 6% final withholding tax. The filing of the estate tax return. The estate tax return is filed within 1 year instead of the previous 6 months from the decedent's death. Again, the 6 months deadline has not been significantly complied with. 1 year is a more reasonable timetable. By that time, the emotions have already died down, and the heirs would be in a better position to undertake the filing of the estate tax return. The estate tax return, supported by a CPA certificate for an estate amounting to 5 million, when the prior requirement is 2 million estate valuation. Now, below 5 million, you need not have a CPA certification on the gross on the estate tax return. And so that completes our second component of our sharing, where we dealt with the changes in the train law on estate taxation. We are now about to go to the details of our discussion on gross estate, which amounted to 20 million in this case, the estate deduction 18,500,000, the net estate of 1,500,000, and the estate tax of 63,000. Let's start the ball on the gross estate. What essentially is the gross estate of a deceased person? The gross estate is the fair market value of all property and assets, real or personal, tangible or intangible, owned by a person or in which he had an interest at the time of his recent death. The recently dead person acquired ownership of his assets and did not sell or donate them inter vivos at the time he died. He had properties, he had assets at the time of his death that he did not decide to sell or to even give away as a donation. The gross estate includes all properties the deceased person owns to include assets in any last will and testament and those which were not included. And so the properties in the gross estate would include intangible versus tangible properties, and by way of mobility, real or immovable properties as well as personal and movable properties. The properties by way of Philippine location can be within the Philippines or outside of the Philippines. And finally, by way of possession and control, the decedent may have his properties under his control or beyond his control. Insofar as possession and control is concerned, those under the control of the decedent would include non-current assets, which are the more significant ones. That would include land, buildings, machinery and equipment, vehicles and cars, furniture and fixtures, intangibles like patents, copyrights, and other intangibles, and finally, investment in stocks and bonds. On the other hand, the current assets would include cash on hand and cash in bank. It will include receivables and claims versus third persons, whether those claims are business related or not. And the current asset will include the proceeds of life insurance, where the amount receivable by the decedent's estate as insurance upon the decedent's own life with or without any revocation. The insurance proceeds to a common law spouse as a beneficiary is void. Any amount receivable by any revocable beneficiary in the policy is included in the gross estate, and an amount payable to an irrevocable beneficiary is excluded from gross income. So, when the designation of the beneficiary is revocable, whether the revocation was exercised or not does not matter. The proceeds of life insurance in such a coverage with revocable beneficiary will require the inclusion of the maturity value among the gross estate subject to tax. On the other hand, if the present default provision in the insurance commission is irrevocable beneficiary as pre-printed in insurance policies, then any award to the beneficiary of such an irrevocable beneficiary will exclude the proceeds from the gross estate. Now, the designation of the common law wife as a beneficiary in life insurance is an act of donation, and under the civil code, persons involved in immoral relationships cannot donate to each other. As a matter of fact, even husband and wife, where they have moral relationship, cannot also donate to each other. Obviously, a common law relationship will not have a superior status as recognizing the designation of the common law spouse as the beneficiary. Still on possession and control, there are assets that are beyond the control of the decedent at the time of his death. That will include transfer in contemplation of death, which will have the following characteristics. The effect of this is that in the listing of the assets of the estate, those transfers, even if not physically under the control of the estate administrator or executor, will still mandate the inclusion of those items in the gross estate for purposes of imposing the estate tax. So here, in transfers in contemplation of debt, the donee takes possession or enjoyment over the property upon or after the giver's death. One characteristic of this transfer. Second, characteristics that the giver retains the possession or enjoyment over the property while he is still alive. So that therefore that would still be considered as property of the deceased person. The giver retains the right over the income of the property until he dies, and the giver retains the right alone or with another person to designate who shall possess or enjoy the property until the giver dies. Any of these four conditions will allow a particular property to be categorized as transferred in contemplation of death, and such transfer will be set aside to include these properties as part of the inventory of the gross estate properties of the deceased person. Continuing with assets beyond the control of the decedent upon death are revocable transfers, and these are transfers by trust, where the giver can alter, amend, revoke or terminate the enjoyment of the property transferred with or without any other person's conjunction. And second, where the power of the giver to alter, amend, revoke, or terminate the enjoyment of the property ends upon his death with or without any other person's conjunction. So revocable transfer is another form of property to be included in the gross estate. Third, property passing under the decedent's general power of appointment. Take note of the distinction between a general power of appointment and a special power of appointment. So if a property is passed on under a general power of appointment, that did not relieve the owner who has become the deceased person of the decedent to have ownership and control of such particular properties. And these kinds of properties are passed on under the general power of appointment either by will or by a deed executed in contemplation of or intended to take effect in possession or enjoyment at or after his death. And then the third is the deed under which he has retained for his life or any period not ascertainable without referring to his death, or for any period which does not, in fact, end before his death. So there are two kinds of these types of deeds. The first one, the possession or enjoyment of, or the right to the income from the property, or the right either alone or in conjunction with any person to designate the person or persons who shall possess or enjoy the property or the income therefrom, except in case of bona fide sale for an adequate and full consideration, the money or money's worth. Another type of property which is beyond the physical control of the decedent is transfers for insufficient considerations. When the giver undertakes a property transfer under a revocable transfer, or a transfer in contemplation of death, or a transfer made under the general power of appointment, but is not a bona fide sale for an adequate and full consideration in money or money's worth, the transfer may be taxable for the insufficient consideration. Not the entire thing, but just the portion that is insufficient. The taxable insufficient consideration is the excess of the fair market value of the property at the time of death over the value of the consideration received by the decedent. Moving now to our main event, which is the gross estate. The gross estate is better listed using the reverse process of accounting. In accounting, the current assets, that means cash, receivables, and inventories, those assets that become cash within 1 year are listed ahead. In the case of estate taxation, it is preferred that the non-cash assets, which are more substantial, be listed first. And so among the non-current assets would be the family home, in this particular case in Parañaque, which consists of the land and the building, the vehicles and cars, the furniture and fixtures, and then the ancestral property like investment in stocks and bonds, and another property is a piece of land in Pilar Village. These are total non-current assets. And by way of their composition, since the couple have been married under the regime of absolute community in the family code, the following would be the valuation at fair market value. For the family home, you have an 8,100,000 value of the land plus the building of 10 million. Therefore, this particular heir would deserve 18,100,000 for the family home. Included are cars worth 4 million, and then another set of cars for 2 million. That would allow us to say that we have 24,100,000 as the valuation of the resources of the person whose estate is being considered. If we were to look at it by way of dividing this individual absolute community property between the two spouses, the rule is 50-50, so that in the case of the land and building of the 8,000,001 total, then only 4,050,000 and 4,050,000 goes to the individual surviving spouse and the decedent's estate. In the case of the building, 10 million, 5 and 5, and so that totals 9,050,000 on both sides of the spectrum. For the vehicles, again, absolute community, 50-50, so the 4 million in assets would now be divided equally 2 million and 2 million. Same is true with the furniture and fixtures, 2 million. You split that between the surviving spouse and the estate of the decedent, that's 1 million each. And there is this exchange, strange thing like ancestral property that were donated by the father to the son. So you have a father decedent and a son decedent later on when we go to vanishing deduction. So the investment in stocks and bonds, you have 450. So the total with the land Pilar Village at 2,880,000, that accounts for the 3,330,000 that this particular husband was using. And so out of the absolute community of property of 24,100,000, all the absolute community were divided 50-50 except the ancestral property that rightly belongs to the surviving spouse and to the husband will obviously be given to him by way of his ancestral property being constructively given to him. In the area of total current assets, the spouses may have cash on hand in banks, not so many, 6 million. And so you have now, therefore, the current assets amounting to 11 million divided by uh, uh, what they call this, broken down into 6 million in cash on hand and in banks. Chances are this might be time deposits and other types of investments. Life insurance proceeds, where you have a revocable beneficiary. So if that particular insurance is referring to decedent on its own life, then that particular, and it indicates a revocable beneficiary, then that revocable beneficiary will now require the inclusion of such life insurance proceeds as part of the gross estate. And then also you have your retirement claim under Republic Act 4917, where the involuntary separation of an employee deserves an award for involuntary separation. And so you have a total of 35 million 100 in absolute community, but excluding the 3,330,000 in ancestral property by the surviving spouse. On the split on the receivables, life insurance proceeds of a revocable beneficiary would normally fall within the context of absolute community. However, if the life insurance proceeds were taken out by the decedent on her life, then that particular proceeds belongs to her because she was the one who insured herself. Of course, there is a school of thought that that should be divided by way of the surviving spouse and the decedent. The retirement claim is coming from the employer of the deceased person. And again, it can be contested that this should be divided equally 1,250,000 each for the surviving spouse and the decedent. However, there is a certain degree of unfairness here because the retirement claim had nothing to do with the surviving spouse. It had something to do with the good employee who was a decedent. And so your total current assets now for the surviving spouse is only her share or his share of the 3 million cash on hand and in banks of 6 million. And for the decedent, he will have added in his current assets the receivable on life insurance proceeds and retirement claim to bring your current assets to 8 million and therefore finalize your estate at 20 million 50. That's 9 million there. Makes it 10 million 50, 12 million 50. I think that's more than sufficient already to explain. Now, here in the absolute community property, all property owned by either spouse, this one, becomes jointly owned conjugal property when the marriage is celebrated. The default marriage regime for marriages on or after August 3, 1988, when the Family Code came into place. The absolute community cannot be modified during the marriage. Properties owned by the spouses during the marriage and those acquired during the marriage are absolute community to be equally divided between husband and wife. In the case of life insurance proceeds with the revocable transfer, this is again being emphasized that the insurance proceeds with the revocable beneficiary is subject to the 6% estate tax even when there was no revocation. And you have now, of course, your retirement claim under Republic Act 4917 of 1967, the death or involuntary separation benefit resulting to involuntary separation from employment is compensable, but that the amount received from that retirement claim, if you really come to think of it, is really belongs to the decedent who got terminated for involuntarily because of her death. Continuing with the gross estate, exclusive ancestral properties. Ancestral properties acquired during the marriage through gratuitous transfer, including the fruits of such donated property, are exclusive properties of each spouse. Unlike in conjugal partnership of gains, when there is a donation of ancestral properties during the marriage, they become part of the conjugal partnership of gains. In the exclusive community property, they are not part because they, they, they were not jointly owned by them. It was given to them as a gift during the subsistence of their marriage. Again, the decedent's estate, and this it is the one, refer to the share of the decedent in the absolute community here. The share on the land, which is 8 million one, is 4 million 50. The building is 10 million, or only 550. Vehicles, again 50-50. Furniture and fixtures, 20 million. Again, the same. Just to graphically illustrate what is happening to our estate, that is the subject matter of our discussion. The absolute community property amounted to 35,100,000, and this does not include the ancestral property. It's an absolute community. And so the decedent essentially gets 50% of that one. And therefore, the surviving spouse would somehow also get his share. But this time it is only 15 million and 50. At the same time, the surviving spouse gets an ancestral property, and also the surviving spouse therefore will get 18 million. There you have it. So here is a very beautiful schematic diagram of how the thing looks like. Now, the valuation of properties in the gross estate. For example, the real tangible properties will be valued at fair market value based on the BIR Commissioner's Blue Book or the provincial or city assessors in the schedule of values, whichever is higher. For intangible properties, shares of stocks, if they are unlisted, common shares or unlisted preferred shares, they will be subject to estate taxation at fair market value, and in the absence of fair market value, you can probably say book value per share with no appraisal surplus, or net for preferred shares, or for preferred shares you use the par value. For shares of stocks that are listed in the stock market, again fair market value on the date of death, arithmetic or proven mean or average quotation, highest or lowest the date of death of the shares of stocks. You will also have participation in association, recreation, or amusement clubs. They normally have membership shares that are traded in the market. Use of wrap, use of notification. And so we are now about to go into the details of our estate allowable deductions. The concept of deduction means that deductions are reductions in the gross estate provided for in the Train Law, Republic Act 10963, and the Tax Reform Act. Tax Reform Act under Republic Act 8424 of 1997 to arrive at the taxable 6% net income. Let us now go into allowable estate deductions. The first group of estate deductions are what we call regular deductions. And they would be expenses, losses, indebtedness, and taxes that we can abbreviate by reverse order. T for tile is taxes, I is for indebtedness, L is for losses, and E is for expenses. Tile. Okay? And these are the regular deductions under tile. Claims against the estate, which are payables, unpaid mortgages and indebtedness. You have claims against insolvent person, these are essentially bad debts. And then you have losses during the estate settlement and property previously taxed or the vanishing deduction. Let us take a look at claims against the estate. Under the claims against the estate, that is the obligation of the estate, the debt instrument is notarized at the time the debt was incurred. And this is a carryover from the provision of the Tax Reform Act of 1997, and there are no indications that they have been reversed in the train law. Second, the administrator executor submits the disposition of the loan proceeds if the loan was contracted within 3 years before the decedent's death. Next of the regular deductions will be unpaid mortgages and indebtedness. And this would be in the following: unpaid mortgages or any indebtedness upon a promise or an agreement where contracted bona fide and for an adequate and full consideration in money or money's worth. And finally, claims against insolvent persons. We are reminded, of course, of the Philippine Refining Unilever decision involving bad debts write-off, even when the case is in the area of income taxation, the same logic would apply. So, for a claim against an insolvent person to be considered bad debts for estate tax purposes and therefore a deduction, the debt should be valid and subsisting, meaning they are collectible. The debt ascertained to be worthless and uncollectible even in the future. In other words, there is no chance of collecting that, and they become worthless and uncollectible. They will form part of the claims against insolvent persons. And debt may be from non-business, personal or business, which is to distinguish it from income taxation, where the business would be somehow related to business. Next would be losses from estate settlement. In losses attendant to estate settlement, you have here the following guidelines on losses. Losses are estate deductions when incurred during the settlement of the estate. And what would be the nature of the losses incurred? They are acts of God or man. They would be fires, you will have floods, you will have lightning, you will have earthquakes, you can have storm. There is no shipwreck there, but there can be shipwreck or other natural disasters. Or it can be man-made by way of robbery, theft, or fraud. Now, the losses are not compensated for by insurance. The losses were incurred not dated on the last day for the payment of the estate tax, which is 1 year, and the losses have not been claimed as a deduction for income tax purposes in an income tax return. So that has to be very clearly a distinction. If the loss was already included among the tax deductibles for income tax purposes, there cannot be any double counting where the same losses will be claimed under estate deduction. And on this particular sheet, we have property previously taxed. We will try to go into that later. Additional regular deductions will include transfer for public use, death or involuntary separation benefit, and life insurance proceeds with revocable beneficiary. In the case of transfer for public use, the taxpayer may decide that to give all requests, legacies, devices, or transfers to or for the use of the government of the Republic of the Philippines or any political subdivision, those that are exercising administration and control of certain public functions. When there is a donation to them, that is deductible from the estate to be taxed. Second, such benefits, legacies, devices, or transfers are for exclusively public purposes. The other kind of deduction would be death and involuntary separation benefits. The taxpayer under Republic Act 4917 is entitled to retirement benefits in a private firm which is exempt from all taxes and shall not be liable to attachment, garnishment, levy, or seizure by or under any legal or equitable process whatsoever, except to pay a debt of the official or employee concerned to the private benefit plan, or that arising from liability imposed on a criminal action when the same comes from a reasonable private benefit plan maintained by the employer. Continuing with death and involuntary separation benefit, in case of separation of an employee or official from the service of the employer due to death, sickness, or other physical disability, or for any cause beyond the control of said employee or official, any amount received by him or by his heirs from the employer as a consequence of such separation shall be exempt from all taxes, which includes the estate tax. And so those are the items that would be included in allowable deductions. Let's take a look at some more. This one was not originally flashed a while ago, and so we have from the regular deductions, we move to the special deductions. And in the special deductions, we have two major significant items, the family home and the standard deduction. In the case of the family home, well, this talks about the life insurance proceeds with revocable beneficiary. Let's just go over it. An amount receivable by the decedent's estate is executor administrator as insurance for policies taken out upon the decedent's own life, irrespective of whether or not the insured retained the power of revocation is included in the gross estate. So, when there is a claim for life insurance proceeds, but there is a revocable beneficiary, then such an amount will be included in the gross estate of that particular person, but also entitled to a deduction in the among the deductions. Any amount receivable by any revocable beneficiary in the insurance policy is to be included in the gross estate subject to the 6% estate tax. An amount payable to an irrevocable beneficiary is excluded from gross estate, and the designation of a common law spouse as beneficiary is legally void. The proceeds belong to the estate of the insured and does not ipso facto vest the legitimate spouses of the right to acquire said properties. We are now ready to click in family home. There is the family home now. And the family home is a special estate tax deduction where an amount equivalent to the current fair market value of the decedent's family, provided, however, that if the said current fair market value exceeds 10 million pesos, the excess shall be subject to estate tax. If you remember, this used to be only 1 million under the Tax Reform Act. Now, under the Trin Law, this has been increased from 1 million to 10 million entitlement. And so that essentially covers our subject matter on estate deductions. However, it may be worthwhile now to present property previously taxed or vanishing deduction. Under Section 86A of the Tax Reform Act, and there has not been any major change under the Trin Law. Quoting the provision, it says, an amount, meaning vanishing deduction, is an amount equal to the value specified in the tax code of any property forming a part of the gross estate situated in the Philippines of any person who died within 5 years prior to the death of the decedent or transferred to the decedent by gift within 5 years prior to his death, where such property can be identified as having been received by the decedent from the donor by gift, or from such prior precedent by gift, bequest, device, or inheritance, or which can be identified as having been acquired in exchange for property so received. By way of trying to focus now on the highlights of vanishing deduction is a property which the decedent received from a prior decedent as a gift, bequest, device, or inheritance, or acquired in exchange for property so received. The prior decedent giver died within 5 years prior to the current decedent's death, or transferred to the decedent by gift within 5 years prior to his death. The intent of vanishing deduction is a sorry The intent of vanishing deduction is not to burden the second decedent's estate with double taxation on the first year of immediately successive deaths. The vanishing deduction is 100% deductible for the second decedent when he dies on the same year as the giver. The deduction goes down by 20% every year after the giver's death until the deduction becomes zero when the incumbent decedent dies 6 years after the giver. Continuing now, it says, this deduction shall be allowed only where a donor's tax or estate tax was paid by the donor or the estate of the prior decedent, and only in the value of such property determining the value of the gift, or the gross estate of such prior decedent and only to the extent that the value of such property is included in the decedent's gross estate, and only if in determining the value of the estate of the prior decedent, no deduction was allowed under paragraph 2 in respect of the property or properties given in exchange therefor. Where a deduction was allowed to any mortgage or other lien in determining the donor's tax or the estate tax of the prior decedent, which was paid in whole or in part prior to the decedent's death, then the deduction allowable under said subsection shall be reduced by the amount so paid. Such deduction allowable shall be reduced by an amount which bears the same ratio to the amounts allowed as deductions under paragraphs 1, that is the tile law, and 3, which is the transfers for public use of this subsection, as the amount otherwise deductible under said paragraph 2 bears to the value of the decedent's estate. Where the property referred to consists of 2 or more items, the aggregate value of such items shall be used for the purpose of computing the deduction. So let us now take a look. It's a very long codal provision with a lot of winding terminologies and sentences. It will be worthwhile now to go over it in simpler terms. First, the valuation of vanishing deduction. Vanishing deduction is allowed only when the donor paid the donor's tax or the prior decedent giver paid the estate tax. First requirement. Second requirement, the value of the gift is the value of the property used in paying the donor's or estate tax. Third, the value of the prior decedent's gift did not avail of any vanishing deduction. So there was no vanishing deduction on the part of the earlier decedent. And we will call that decedent the father decedent versus the son decedent. So we don't have to use prior decedent to say father decedent and son decedent to make it simpler. The vanishing deduction is reduced by any mortgage or lien which the giver paid prior to his death and accordingly reduce his donor's or estate tax. And finally, the allowable vanishing deduction is reduced by an amount of the value of the gift times the ratio of the taxes, indebtedness, losses, and expenses, your tile, plus transfers for public use divided by the gross estate. Okay, so tile plus transfer divided by gross estate, you get the ratio. You use that ratio against the value of the gift, and that particular gift becomes a reduction, a subtraction from the claim value of the vanishing deduction. To illustrate vanishing deduction, it would be worthwhile to take a look at a father giver trying now to give a house and lot as a gift to his son, who is married, gainfully employed, and was not craving for the donation or gift from the father. From that point, the father passed away on January 20, 2021. And so, when we follow through with the telenovela, the son decedent followed from January 20, 2021 on September 15, 2021, the same year, he passed away. And so the gift that was given to him now will allow his heirs to consider that particular gift a vanishing deduction. And so now you have your son decedent's estate on September 15, 2021. He has his family home, and he has his cars, and finally he has his ancestral property given to him by his father. Continuing with the vanishing deduction scheme, we have here the father giver again. We will again replace the flow of transactions. There is the son receiver, and there is the father decedent on January 20. He died. And on September 15, 2021, his son also died after he has given that gift. And that therefore allows us to say that that property, that there was a big container of money that was given to the son. But the son decedent died within 5 years from the father's decedent death, in fact within the same year. And so the vanishing deduction is a property. Here is the property which the decedent received from a prior decedent, his father given, as a gift, bequest, device of inheritance, or acquired in exchange for property so received. The properties under vanishing deduction are properties in the Philippines received as a gift from a donor, donation inter vivos. Property in the Philippines received as a gift, bequest, device, or inheritance from a minor, from a prior decedent, donation, mortis, causa. And any property in the Philippines acquired in exchange for said gift, bequest, device, or inheritance from a donor or a property giver, resulting property acquired in exchange for the original property under vanishing deduction. The intent of vanishing deduction is repetitive now, is not to burden the second decedent estate with double taxation on the first year of immediately succeeding debts. The vanishing deduction is 100% deductible for the decedent when he dies on the same year as the giver. The deduction goes down by 20% every year after the giver's death until the deduction becomes zero when the incumbent decedent dies 6 years after the giver. Here is a sample of the period of vanishing deduction. The father decedent died on 2021. The son decedent also died on 2021. The ancestral property donated to him of 3,330,000 is 100% deductible up to only 10 million. And the second tier is if his father died on 2021, but the decedent filed only on 2022, which should prevail. Okay, theoretically, this will now be at 80%, so the 330 now can only be 80% tax deductible on the second year. It will only be 60% deductible third year, and so on. The allowable vanishing deduction is reduced by an amount of the value of the gift times the ratio of taxes, indebtedness, losses, and expenses, plus transfer for public use divided by the gross estate. And this is how it is computed. You have your tile of 1,000,009, and for public use is 2 million. You have a total of that amount of 2 million. Gross estate is 18,380 divided by 2,000 divided by 18,380. What we will arrive at is 10.9 million that you multiply against the 3,330,000. So the reduction in allowable vanishing deduction is 314. And so the 314 is deducted from 3330, we have 316. And so We now have the property previously taxed, taken care of already. We have already discussed transfers for public use, death of involuntary separation, life insurance, special deductions, and family standard. We have already mentioned to you, and we will reiterate, the deductions that have been discontinued and deleted under the train law would be the funeral expenses, judicial expenses, and medical expenses. For non-resident alien deduction, the tile, taxes, indebtedness, losses, and expenses for non-resident aliens have been deducted, have been removed as a deduction. But in their case, the standard deduction has been increased by 500. And so that essentially ends up our coverage of estate taxation. And so the gross estate is 20 million, the estate deductions is 18.5 million, and we've gone to that. And so the net estate therefore is the residual of 1,550,000 subject to the 6% tax, giving us an estimated tax due of 93,000. And so, ladies and gentlemen, we end up our humble upload on the estate taxation under the train law. In closing, allow me to, again, as I said, dedicate this little and humble expression of my loving memory of my father, Captain Santos Margas Bisquera, a retired officer of the 1st Tabak Division Armed Forces of the Philippines, which he served even as a young man in the trenches of Bataan. And my mother, Dr. Natividad Bernardo Balagtas, a veteran teacher at the UE High School Department for years. I would just like to remember my parents in relation to estate taxation. My parents have always told me that they have nothing to pass on to us as their inheritance. And so we should work so hard in order to provide for ourselves. And so it came to pass that I came to realize while growing up how thrifty, how frugal my father and my mother was. My mother especially was so stingy that once money comes to her hands, she would no longer release that money. And when she brings it to the bank, she has a tendency to forget she has money already there intentionally. And so I grew up in a situation where we had humble standard of living, lower middle income group living in Sampaloc, Manila for years. And the main reason why I had to study very hard and top my academics is because without the scholarship that I would have gotten, I probably would not be in college. As a matter of fact, my father was telling me to be a member of the UE band, to play in events, including the basketball games at UAAP. I almost took pity on myself that in order to study in college, I have to be a drummer of the school band, if only to continue my studies. And I was good as a snare drummer when I was a Boy Scout at the University of Santo Tomas. But instead of availing of such special benefits. I tried very hard to study and perfect my examinations and my subjects simply because I needed to. And I saw how thrifty my parents are. Our allowances were, my allowance was so meager, I can barely buy anything for myself. I was surprised that when finally they became a little old and I already have my own family and I was starting to earn my living, that my parents were able to save tremendously, that when they passed away and I took an inventory of their estate, they have three properties, house, valuable lot. One in Pilar Village in Las Piñas, a 240 square meter lot, where their ultimate family home was established, and two lands of about 240 each, also in Molino, Green Valley they call it, Bacoor, Cavite, which was almost of no significant value at the time they bought it. But when I took the recent survey with the establishment of SM Bacoor, the value of those properties went up. And so with three real estates left by my parents, the three of us children, my brother, my sister, and myself, have something to cling on to, despite the fact that my parents said, we have nothing to pass on to you. And so while I was liquidating the estates of my deceased parents, when I started teaching as a bar reviewer at the University of Manila, I learned the rudiments of estate taxation. And in the 1994 bar examination, I ventured to lecture on estate taxation using the information, data, and knowledge I learned out of trying to file the estate taxes for my parents. And there I was, my first time to be a bar reviewer. And one half of my review class at the University of Manila were my former classmates at the UE Bar Review. And obviously, they did not expect anything new from me. So when I started on the pre-week lecturing on taxation, and I brought in Vanishing Deduction, one half of the class walked out on me. Because they say, he's a greenhorn, he was just our classmate a few months ago. And now we're patiently listening to him and he lectures on Vanishing Deduction, a subject matter that has never been given in the bar examinations nor even in the CPA board. So they walked out on me and I felt very sad. In the 1994 bar examination, for the first time, Vanishing Deduction was asked as Roman numeral number 1, problem number 2. And there was only one other bar reviewer in the whole Philippines that tipped Vanishing Deduction to come out. He was my professor in Civil Law Review, Commissioner Jose Noliedo. So only Noliedo and Bisquera tipped Vanishing Deduction and he came out. And that became a very sentimental memory for me, reminding me that the only reason why I could lecture on estate taxation is because my parents managed to save so much money with very thrifty and frugal standard of living to allow us to have three valuable pieces of land that we have now as their children. So my lecturing on estate taxation is a beautiful memory of my parents' hard work and frugal living, literally tipid na tipid, noon pala, merong maiiwan sa amin na konting mana that can now be worth a couple of millions among the three of us children. Marami pong salamat, my dad, Captain Santos Vargas Bisquera, Banged Abra, and to my mother, pinakamatipid na nanay na nakita ko, Doktora Natividad Bernardo Balagtas Bisquera, from Santa Rosa, Nueva Ecija, Candaba, Pampanga, and Balagtas, Bulacan. I sentimentally remember you now with my lecture. And for those of you who are listening into this upload, this is one of my more beautiful lectures. Even when I was starting to feel a little sleepy already, having gone to bed at about 1, 2 o'clock every night for the past week or so in order to complete this. Marami pong salamat, and I hope I'm able to allow you to understand the more simple manner of looking into estate taxation. Thank you very much, and I look forward to your viewing my other YouTube uploads, and also to click the subscribe button somewhere down here to allow me to have my countdown with Google and YouTube. And so, let me see you in additional uploads. Marami pa po. Naka-standby po yung upload ng insurance. Malapit na rin po yung legal ethics. Ready na rin po yung transportation, all the fields of transportation. Hindi po tayo mauubusan ng lecture sa field of law. And meron na pong ready slide, legal ethics, and I hope that I can share this with you. This is my dedication also to you, my dear friends who are reviewing for the bar examination and also for the CPA board examination, the toughest government examinations among professionals in this country. And to all my countrymen who were frustrated law students like me before, huwag po kayong mag-alala kasi po, sabi nga, ignorantia lehis neminim excusat. Ignorance of the law excuses no one for compliance therewith. Kahit po siguro hindi kayo sinwerte, hindi kayo naglakas na loob na pumasok sa College of Law, with the series of YouTube lectures, you will be better than many of the lawyers who no longer update themselves. So I'll see you soon. Maraming pong salamat sa inyong lahat.